Welcome to another edition of Life, Death, and the Law. Thomas, we're going to be discussing crime surge here in Yuma County and across the country. So this is something that all homeowners need to be aware of. Not only homeowners, but owners of real estate, anywhere, property rights that are recorded by virtue of deed. And what is happening is fraudsters are going and they're forging a deed in your name, conveying your property to somebody else. Now, they may have some type of private arrangement that they've found some unsuspecting victim to purchase this property at an unbelievable price, and they say, well, I've got to go out of the country, or they come up with some very sympathetic story to determine that it's got to happen quick. It's got to happen before we can get title insurance, and I need cash or some type of funds that you're not going to be able to get back. And so they do this when they record the deed. They hand it to you, and it looks legit. The deed is recorded at the county recorder's office, and since the recorder stamps it and it's literally there as part of the official record, it looks like this transfer has occurred. Mm-hmm. However, they were not the actual property owner. So they can't convey the property. And what happens is, not only did the victim purchase a piece of paper that is worthless and not own the dirt that is represented by that deed, but that the property actual owner now has a deed out there that indicates they don't own the property, and there's going to be some legal issues when they go to sell or refinance the property.
Yeah, and the difficulties I think we see a lot of the time with this subject is a lot of times there's a big passage of time when it comes to the time when they got the deed from this fraudster versus the time where they actually find out that it was falsified. Sometimes it can be a matter of years where some other person comes back to their house.
How often do you go down to the county recorder's office and just take a look at your deed, make sure it looks good?
Peruse the files and see what's going on, and say not very often. So it can take a while, and the longer this fraud is allowed to occur, the harder it is to prove, who owns the property legitimately.
And so when the problem comes up and is discovered usually is when you go to refinance or sell the property, because that's when an individual title company is going to go in and link all of the prior transfers to that property and verify, yes, you are the bona fide owner of the property, and you can sell it to the buyer that's proposing to give you fair market value for your property. And that's why title insurance is so important. If you're thinking about cutting corners or skipping steps to save money, maybe you want to do a first sale by owner. What is that called? A FSBO?
Yes.
Is that the actual term for it?
I'm not sure.
Okay. For sale by owner. Mm-hmm. And maybe you want to do that because you figure you can market your property just as well as a realtor. But what you do not want to skip is going through escrow and specifically the title insurance aspect of it. Particularly if you're the buyer, you want to make sure that the title that you're acquiring, that you're paying the money for, is actually in the name of the person that you're buying it from and going to be transferred legitimately to you. And if it doesn't get transferred legitimately to you, then the insurance is going to make sure that happens. They're going to file the legal claim in court to make it right and get you the title to the property, or reimburse you for the fees that you paid for the property if they can't get you the title.
Yeah, I think one of the things that comes to mind are typically there are a few different number of deeds you can have. I think when I see some of these fraudulent transactions in the past, they're done via quitclaim deed.
Yeah.
So let's talk a little bit about the different types of deeds you can have. So quitclaim deed means that if I own a property or if I don't, but if I legitimately transferring a property via quitclaim deed, I'm not making you any promises as to if I own it, as if it's got clean title or anything like that. I'm just saying it's kind of like a buyer beware type of deed. And then after that, you move up.
You're saying I am only conveying to you whatever title I have to this property, and I'm not saying I actually have title to this property.
Yeah, it's total buyer beware. It's on you, and you're taking a risk. Then you have the special warranty deed, which is pretty typical in today's world. It's the buyer who's giving that deed to a seller is only warranting to them that they didn't mess up. Like, when I had the property, I knew it was mine, and I had legal title, and I didn't do anything nefarious or wrong.
Yeah.
And then
I don't have any loans against it.
Right. That's a special warranty deed. And then you have the general warranty deed, which isn't really used very much anymore, frankly, because people don't want to take on that much risk. What that one is saying is, I didn't do anything wrong, and nobody in the previous chain of title before me, going back to the origins of the property, has ever done anything wrong. And what you're warranting with these deeds is you're giving certain covenants that there's no encumbrances, no liens, like you said. And I don't know about you, but I don't want to promise that on behalf of someone who owned my house 100 years ago.
Well, that's a double-edged sword, though, because if I bought the property using title insurance, then I want to convey that property to my child. I want my child to have the same assurance that the title was covered by the title policy, and they get it. And so there's an argument that if I use a warranty deed to convey it to my child, then everything that I acquired under the title insurance gets passed to my child. So if there's a claim that comes back and says, well, somebody did something in the meantime, or even prior to me acquiring title, that title insurance, I can make a claim against it. My child makes a claim against me first, and then I make a claim against my title insurance because I conveyed it by warranty deed. But if I don't convey it by warranty deed, then the title company is left off the hook.
So you're saying that, well, that could be accomplished with special warranty deed, right? Because you're saying that everything that happened while I owned it is good to go and up to speed. So you can always indemnify the title insurance for you.
I don't think that it goes back before you, though.
Right. That would be.
And so if the title company missed something before you acquired title,
right,
that special warranty deed wouldn't bring back the title company's insurance into the picture.
So yeah, it's more of it leaves you exposed.
Leaves you and your child exposed.
Because your child would have a claim against you.
Yeah, but I'm doing it for the benefit of my child, right? Me and my child both have the same interests.
Right, yeah. So that is true. However, general warranty deeds, typically, it seems that people don't really want to use them.
So when we do a deed to a trust, we use a warranty deed.
We do. We use special warranty deeds.
I thought we used warranty deeds.
Yeah, well, the warranty deed is a shortened form of special warranty because there's general warranty and special warranty.
Interesting.
Yes.
So you recently took the bar.
Yeah.
So you got to go through the particulars of this. So when I'm saying warranty deed, I'm inferring special warranty deed?
Yeah, most oftentimes. So when you talk about, like, speaking of all of the crazy scenarios you study when you're taking the bar exam for property law.
And let's just get clarification here as to why you recently took the bar exam. So you've been licensed to practice as an attorney for 6 years.
Yes.
And you are a practicing attorney currently. You currently practice under our license for things that you do in Arizona, but you've been licensed in Washington for 6 years. And then you recently got licensed in California, and you're currently getting licensed in Arizona through reciprocity.
Correct, yes. Yep, so I took the bar exam in California is the one I'm referring to just this last year.
Yeah, and so you had to study all that, and California is known to be one of the more difficult bar exams in the nation.
That's what they say, and it was, it wasn't a walk in the park, but got it done, so that was a blessing.
Okay, and that's good because, it helps as a refresher course. Attorneys do have to go to continuing education courses to continue practicing law. It's 16 hours a year that they are required to take, but they can take it on anything. I can take it on criminal law, right? It has nothing to do with title insurance or property law, and I can be totally out of the loop. And in this case, you've reminded me of something that I might have known as I took the bar and didn't remember. But so the special warranty deed and a general warranty deed are two specifically different things. And if I don't use that term general, then I'm inferring the lesser of the two, the less comprehensive version.
Yeah, I think in today's age, there's this implication that special warranty is the more popular pick. So usually when people are saying warranty deed, they're referring to that one. But I mean, that would be an interesting, that's a whole different interesting can of worms. Like if you're going to court on a quiet title action because you have this argument about who owns a property, I mean, that would be something that would come up is, well, which one did you mean? Because all you put was warranty deed. Yeah.
Martine, I want you to fact check us on this.
Yeah.
So ask ChatGPT when we do a warranty deed to transfer title to a property, and we don't specify whether or not it's a special warranty deed or a general warranty deed, what is inferred there according to the all-knowing AI. Okay, so I want to get back to this fraudulent transfers and what people can do to make sure that their property is not being, we use the word encumbered, which isn't, your typical lingo, but what that means is that somebody else has done something to your title to make it difficult for you to sell your property or to get a loan on your property. And so typically, like I say, individuals will find a property and that generally can be sold for a cash amount and far under fair market value. And they need to do it quick, and they'll come up with some sympathetic story to do it. And then somebody comes in and says, this is too good of a deal to pass up. And the story holds that if it's too good to be true, it usually is. So they go and they purchase this property. And then 2 years later, it happens to be your property that was sold by this fraudster. You go to sell your property. You think all is fine. You hire a realtor and you get a buyer. You've got 30 days to close. All that's left is the formalities, the title company to go through and verify that everything looks good. And then boom, this red flag pops up that somebody, Jack Black out there, has conveyed your deed, forging your name, and John Doe now theoretically owns it. And so you've got to go and say, no, that wasn't me. I didn't sign that deed over to John Doe. And the notary, you're going to go back to the notary book or whatever and verify that that wasn't you that signed it and it's not valid. That's going to cause a delay in that transaction. You may lose the buyer because of that, and you're going to have to go to court and file a lawsuit against John Doe, essentially claiming he doesn't own title to the property because he was defrauded and the deed that he received wasn't real. Mm-hmm. And that's where the problem comes in, the delay that occurs. Now, you could be incurring the cost of that litigation, which could be expensive. And it's called a quiet title action, which is kind of a weird name. But quiet title action says that I own title to this property and nobody else owns title to this property. Nobody else has a higher claim to this property than I do. And so that's what has to happen. Now, if you've got good title insurance, typically you go back to your title insurance when you purchase the property and say, I purchased insurance that I'm the title owner of this property, and so I want you to go in and file this claim in court. That is some, I guess, redeeming aspect of it, but we all know that lawsuits take a long time, and so your life is going to be put on hold, and that's going to cause you maybe that transaction, maybe the market turns, maybe the move that you're doing right now cannot be prolonged, and so you're going to be in a new house paying a mortgage on two houses. So a lot of bad things can happen during that, even if the title company comes in and pays for that to be resolved. So the damage can't be undone there.
Yeah. So, Martin, do you have an answer here for us?
In Arizona, if you use a document titled simply a warranty deed without specifying special or general, it's interpreted as a general warranty deed.
Okay, there you go. So we're doing general if we don't specify.
So I can't remember who was right on that one.
I think you are. So we got to pull up our deed, and we got to make sure what our terminology is.
I like it though. I like conveying a general warranty deed, and I've done that on purpose. I do remember researching this back when we started conveying properties to trust, and this is for me 11 years ago when I researched the issue. It says if you don't convey it under a warranty, then the title policy doesn't travel with you. And so you could unknowingly convey your property to your trust and nullify your title insurance.
Yeah, if you quitclaimed it to your trust.
And a lot of people do have that happen when they go to this discount firm or this paralegal or legal document preparer, and they say, yeah, all you got to do is quitclaim deed your property into your trust and it's good to go. There are some nuances to it that you want to be aware of.
Right. And just for people who are scrambling to look at their deeds now to see what they say, like in your scenario, a special warranty deed would also work because you're only giving it from yourself to your trust. And a special warranty deed would cover you for transactions that you are giving to your trust.
Okay.
So it shouldn't nullify it just because you're using a special if you're only talking about conveyance from you.
Correct. But my argument is why do that? Why limit the transaction between the time that you purchase a property or the insurance between the time you purchase a property and the time you convey it to the trust? I want it to be insured for all time.
For the life of the property.
And that's what I purchased when I got the life insurance, or not life, when I got the title insurance when I purchased the property.
Right. I think that is wise if you have that title insurance and you know that the policy will cover the life of the property. So that's something to look into.
And you can get title insurance after the fact. So if you inherited property, and you didn't get title insurance on it, or some other way you got the property, you can go to a title company and say, hey, I'd like to get title insurance on this property. You can pay the insurance for it. I think, I don't know how much it is for title insurance generally, but it seems to me that it's like between 1 and 1.5% of the value of the property.
Okay.
Maybe, Martine, you can fact check me on that. What's the typical cost of title insurance for property?
So it's 0.5% and 1% of the home purchase price, with the premium between $1,000 and $4,000.
Oh, okay. So it's between 0.5% and 1%, with another premium of $500 to $1,000.
Gotcha. And will that title insurance company, will they cover transactions prior to your ownership of the property?
Well, that's specifically what it is.
What I had searched though was the transferring through Quitclaim, and it says that you would lose your title insurance in Arizona if you quitclaim the property, because it violates continuation of coverage, because the quitclaim doesn't offer any warranties.
Gotcha. Yeah. So we're tracking right along there.
Okay, perfect. So when you come and do a trust with Deason, Garner, and Hansen, then you're going to get a warranty deed that conveys your property into your trust, which is going to maintain the continuity of the title insurance that you acquired when you purchase a property in your trust. And so those are important things to know. Another thing is, what can you do to have early detection for some fraudster tampering with your title?
What can you do? Well, that's something that we've really, I feel like, needed in the community, where we could have an alert so we don't have to be surprised 15 years down the road when we're trying to sell our houses. And we just got notice from a little newspaper clipping that we have here, where there is something you can do now to actually key in and be alert to these potential fraudulent transactions.
Yeah, this newspaper clipping was brought into me by a client, and I don't see a date on it. Here it is. Sunday, January 25th, 2026. I think that's the client's handwriting too. Our clients are so good.
Yeah, they're great.
So this newspaper article basically is from the sheriff's office, and it warns against home title fraud, and it talks about this new program that the county recorder office is offering to the public for free. So you can go onto the county recorder's website, and immediately when it comes up, there's going to be two big options when you do for a property search. And one option is just proceed to the property search, and the other option is to register your property to be notified if anybody else is recording or trying to encumber your property. And so you'll get an email notification of that. It only takes a few minutes. We've done it for clients. I've been helping clients do it for a couple of months now, just on as they've asked for it, or when they have questions about should they go out and buy separate insurance. A lot of companies are taking advantage of this new wave of fraud that's really spanning the country, and so they're getting out there and they're selling insurance against this. And basically what it is like identity theft insurance, which tracks when people are trying to apply for a credit card under your identity, or use your identity for other things. That tells you that somebody's doing it and helps stop or fight against it sooner than later. Mm-hmm. And they offer insurance that they'll go to court for you and fight to get your identity cleared. Of course, that all goes with how good the company is and how reputable they are in following through with claims. I think that most of those companies, what they're selling you is an alert system, and that's it. They're going to tell you, yes, we'll give you an alert that somebody's tampering with your identity unless you buy this really high-end premium package. What we're advertising on TV is, for $3 a month or $6 a month, that you can have identity security, but then it's going to be something pretty minimal. This is free, and so there's no reason you shouldn't do it. You should go online. You should register your property to get notifications if anybody is recording a deed or any type of transaction that affects your property.
And it's with the same entity that, is holding these documents.
Yeah, it's not a third party,
right,
that's out there making money off of you, and that you have to try to go through them to go through the recorder's office. The recorder's office is the official location for all recorded property transactions.
Yep. So, you're not going through a middleman somewhere in a call center.
Tell me a little bit more about what you learned when you took the bar, and just more recently, that as practicing attorneys, we may have studied during law school or during the time we were preparing for the bar that we forgot about. What nuances came up to you?
So when I was doing my study, I was already, working here, and we were going through deeds and we were recording deeds. So those property laws really what stood out to me when I was studying, because I could tell that it would have an immediate impact here at the firm. And one of the things that I was learning was the differences of when you have these fraudulent situations, who is protected under the law and really who isn't. And the typical phrase that's used in these in the law is a bona fide purchaser. That's one of the things I learned about.
So what's a bona fide purchaser?
A bona fide purchaser is somebody who purchases a property for value. So importantly, who is not a bona fide purchaser is really the more important question. So if you inherit a property, or if you're gifted property, you are not a bona fide purchaser. And why does that matter? Because then this varies state to state, but we'll use Arizona's law for this example. Arizona is a notice statute state, and that's different from a race statute state. And I'll explain the difference. So this is all about recording documents with the recorder's office. So if you buy a property from somebody and that seller turns around and wants to pull a fast one and sell that property really quick to somebody else.
Yeah. They advertise it themselves. Mm-hmm. They are their own realtor, and then they get one buyer that comes and says, I'll give you $100,000 for your property, and another buyer the next day says, I'll give you $120,000 for your property, and he signs a deed over to both.
To both, right? So who owns the property? Well, someone might say, well, the guy who bought it first. That is not the case in most states. There's a difference on who's recording, right? So in a race statute state, it's a race to the recorder's office. It's whoever records that deed first is going to be the owner of the property. So the person who bought it first for $100,000, if he takes his time recording it, out of luck. The second buyer is the one who owns that property. Now he might have a lawsuit against the seller for.
But not in Arizona.
No, that is not Arizona. That's a race statute. I don't know which states are race statutes. Not very many.
In Arizona, the transaction occurs and is complete as soon as the seller hands a properly signed, notarized deed to the buyer.
Right, with the intent to convey.
Yeah, well, when I'm handing you a deed that I've signed and been notarized, it's hard to argue what other intent I may have.
Well, so that's where you get a little sticky bar exam question.
Yeah.
Where somebody will say, they signed over a deed and it's in their desk drawer, and the intent was for them to give it to the seller or the buyer on their 18th birthday, for example. So there's evidence there that they've conveyed it via signing it, but the intent wasn't to deliver it for years down the road.
But if I hand it to you.
Yeah. We're talking about a pretty solid definition of conveyance.
Yeah,
and that's
you're holding the deed in your hand.
Right. So that's conveyed. So in Arizona, we're a notice statute state. So what notice means is that whoever gets the property last without notice that it's already been given is the winner. So how would that work? If we'll take the other example where seller sells the property to the person for $100,000, they don't record it, and then they sell it the next day for $120,000 to the second buyer. The second buyer has no notice that the first buyer has the property. So the second buyer wins in Arizona because as soon as they properly record their deed, they didn't have any notice of the first person.
How is that different from racing to record?
Yeah, so there's a hybrid statute, which is usually what the majority jurisdictions use. It's called race notice. It's a combination of the two. And
is that us?
No, we're just pure notice. We're a pure notice statute. So how is it different than race? Because I don't even have to record under a notice statute. I win because I bought the property second and didn't have notice that you bought it. So even if I don't record, it's still mine.
Oh, interesting.
Yes. So
it is, but if I buy property, I want to record it pretty quickly because I don't know if I'm the first buyer and they're going to sell it to another person.
Exactly.
If I buy it and record it, then before anybody else buys it, then I own it.
Because the trick is we want to give a subsequent buyer notice.
Yes.
That you own it.
And that's the public policy incentive there.
Right. And when you record something, you have implied notice. Even if the buyer was too busy or too stupid to go look at the recorder's office to see who had the deed, it doesn't matter. You recorded it. It puts everybody on notice. You own the property.
Now, I know that this is a lot of legal mumbo jumbo to some of our listeners, but you may wonder, why does it take a little while after I've signed the deed before I get it back from the title company or from the recorder's office? And that's the answer, because the title company is going to do one last search before they go ahead and issue it. They want to make sure that nobody recorded it already in advance before you.
Yeah, and here's
because they've done their search when they took on the project and said, okay, we've got A is selling to B, Shawn is selling to Thomas. Shawn currently holds title to this property. Thomas currently has cash in the bank to purchase a property. So we're going to put it under escrow. Thomas is going to put his cash in escrow. Shawn's going to put his deed in escrow, and he's going to promise not to convey it to anybody else during this transaction. But when the transaction finalizes and we go and sign everything that completes the transaction, they're going to do one final check to make sure nobody else has recorded this deed, including me, that conveys it to somebody else besides you. And then they're going to record it. And then straight from the recorder's office, you're going to get a copy mailed to you of your deed. And that title company will also give you a copy of your deed that's been recorded, along with the title policy that has all the fine print terms and conditions of what they cover in their title policy. That says, you own it now, and if anything goes wrong with this title, come back to us, we'll make it right.
Yeah, and I think just the theme of today's conversation, like when it comes to preventing fraud it's record your deed, and if
go through an escrow
company, and keep everything above board, and then sign up for this free alert, because why wouldn't you?
Yeah. There are other property transfer techniques that commonly are questioned when we give public seminars. And one is a quitclaim deed, or sorry, not a quitclaim deed, a quiet...
Beneficiary deed?
Beneficiary deed.
Yeah.
Thank you, Thomas. Beneficiary deed. So beneficiary deeds are looked as this quick, easy way to avoid probate and transfer your property to whoever it is, a child or a loved one, and they can work. We have used them, but there are also some important details to remember about beneficiaries deeds. So, for example, in a beneficiary deed, is the recipient a bona fide purchaser?
No.
So they don't get the rights and the entitlements of a bona fide purchaser.
Right. So that would be, all the more incentive for you, as, let's say you're doing a beneficiary deed to your kids, as the parent, to make sure that when you got the property, that it was above board through that escrow company. Because if it was done right through you, and you're doing a beneficiary deed, it's only going to transfer whatever rights you had in the property.
Now, the alternative, and that's why trusts have become so important, and not only for the wealthy, but for anybody that's conveying real property, is they allow you to convey your title, all the title that you have, into the trust, along with the warranties that came together with the title insurance, and then hold it there until the time that you pass away and you want that trigger to then convey that property to your child or to your beneficiary. Then the trustee, who's been holding this title to your property in trust, conveys the property together with all the warranties and entitlements that you had.
Right. And also there's this added, control feature for you as the creator of the trust. If you, under beneficiary deed, your children or whoever you're giving your house to owns it outright, there's no protection from themselves. If they, want to go sell that house and blow the money in Vegas, they can do that. Mm-hmm. And there's no opportunity for you as the owner of the house today to put some provisions on how you want that house used.
And we've seen that all too often, where children who are heirs receive property and they spend their inheritance very quickly. They sell the property, they spend their inheritance. Another thing, now that's their own fault, right? Maybe it's the parents' fault for raising them wrong, but yeah. Mostly it's the kids' fault.
All of our listeners aren't like that.
No, none of our listeners are like that. And so another issue, though, and I think, I know this is a number one liability that affects individuals in America, and that is divorce. Mm-hmm. And what happens many times when people receive an inheritance, if they're married, they're going to receive that inheritance and they're going to title it jointly. And initially in Arizona, even though we're a community property state, if you receive a beneficiary deed to a property, that property is yours. It's not yours and your husband's, even though you were married when you receive the property. However, so if I give it to my daughter through a beneficiary deed, it's not hers and her husband's if I just gave it to her. However, oftentimes what they want to do, if they're going to refinance, they're going to put in some improvements, or they're going to do anything else, they're going to want to do that jointly. Or they're going to do it under whoever's credit is better. And so commonly when they're going through the refinancing process, you've got this loan officer, and the loan officer's job, and I'm not trying to take a dig on loan officers, but the loan officer's job is to get the couple who has come into them as a client a loan. And sometimes they'll run both credits and they'll say, well, husband's credit is much better than wife's. And so combine husband's credit with a deed to the house that wife has, and we can get this loan to go through. But what wife's going to have to do is she's going to have to convey the property to husband, and oftentimes what they have them do is they have them sign a disclaimer deed. And so not only did they now make the property joint property, so if the wife conveys it to husband, it's now technically joint, but then this disclaimer deed says, I don't have any right to the property. Now, all wife's seen at the time is, this is paperwork that I don't really understand that is necessary to get the loan, and so they're signing every paper that comes in front of them, and they're multiple, and she's signed this disclaimer deed, and now the husband acquires a loan. They use it to improve the house. They file for divorce, and the husband says, the house is mine. And the wife says, no, I inherited this from my dad. This is my house. And he pulls out not only the deed from her that conveyed it to him, but a disclaimer deed that says, I don't own any right to this property, and it says, it's mine. And that's a major problem to have. So what we recommend is that when we create a trust, the heir receives their inheritance in trust. And when property is conveyed out of a trust, we typically get a phone call. And when we get that phone call, we get the opportunity. So if you got that phone call and somebody's going through the refinance process, what are you going to tell your client?
Yeah, I'm going to say we need to have a conversation about what rights you're giving up by doing this transaction this way. And ultimately it's the client's decision on what they want to do.
Sure.
But we want to have a chance to educate them as to, did you know that X, Y, and Z is going to happen if you do it this way? Or, some people own property with joint tenants with the right of survivorship, meaning whichever person who survives the other person gets the whole property.
Yeah.
I've had several of those very recently where people didn't want that, and they didn't even know that they had it.
Yeah.
So we want them to come in so we can educate them on the implications of what's going to happen.
So with our clients, and even with the heirs of our clients, we give consultations about those tax or not, those legal implications for free. And that's something that we do because we've been able to gain a reputation, to get a lot of business, and we've been doing very well. And I don't mean this as a brag, but we don't have to charge for everybody that steps into our office or each phone call that we receive, because we do a large quantity of estate planning, and we have those answers right at the tip of our fingertips, and we know the validity of them. It's not just, okay, we've done a web search and this is what we believe. We've seen this to be the case over years of practice. And so when they come in and sit down with us within a period of 45 minutes to an hour, we can let them know exactly the pros and cons of following through with this transaction, and potentially some alternatives that they can accomplish their objective without compromising their inheritance and keeping the title properly in their name. So another way of holding title is community property with right of survivorship. And this has come up several times throughout my years of practice, but most recently, because community property with right of survivorship, Martin, maybe you can look this up, but I think this came up in the early 2000s, that this ability to hold property in this way occurred. It has to be a husband and wife or a married couple. So, any legally married couple can hold community property with right of survivorship. And most people think that it's the same as joint tenancy with right of survivorship, but it's not. Joint tenancy means that if you die, I own the property. Okay, fine. Community property with right of survivorship, if you die, I own the property. Same. Difference is, with joint tenancy, if you die and the property is worth twice as much. So let's say that we purchased the property together for $100,000. And when you died, the property was worth $300,000. Okay, so I get your step up in basis, which is $100,000. So, but I don't.
That half is what you're saying of the difference.
Yeah, the half of the difference. Sorry. So the difference is $200,000. We bought it for $100,000. It's now worth $300,000. It's a $200,000 difference. So you get a $100,000 step up. My difference, my capital gain is $100,000. Okay, because our basis is both the $100,000 together, right?
Yep.
And so if I sell the property and it didn't qualify for any other types of deductions or exemptions, then I owe taxes on the $100,000 that is my gain if it's joint tenancy. However, if it's community property, then when you die, we both get a step up in basis. So now it's as if I purchase a property again for $300,000. So if I go and sell the property, then the capital gains is nothing. So I save $25,000 in capital gains taxes.
Right. And also another benefit of community property, sometimes it's called tenancy by the entirety in other states as well, is...
We don't do that here.
What's that?
Tenancy by the entirety.
Well, yeah, it's this. We have the same rights, but we call it community property. Like, for example, like if in joint tenancy with a right of survivorship, any of the joint tenants can choose to break the right of survivorship. And they can say, you know what, I'm done with this survivorship stuff. I just want to own it 50-50.
Yeah.
And they can do that. Community property requires both tenants to sign off on that type of break.
And acknowledge that they're receiving it that way. If you receive a property and it says this property is going to, let's say, a husband and wife, but it just says John Doe and Jane Doe. That's it. Then the default is that they own it each individually 1/2 interest with a right to the entire property. So it's not like, John Doe can draw a line down the center of the house and say, Jane, this is your part of the house and this is my part of the house. But they both own a right to the entire property, but a 1/2 interest in the value of the property. And so that is tenants in common is the terminology used. And so if wife dies and she has a will that says, I want this to go to my daughter, who was my daughter prior to this marriage, then husband now owns this house with wife's daughter, who is his stepdaughter, who never got along with him, and that's a problem.
Right. Yep. So that's all the things that we do when you come in is we look at your deed to your property when we do these consultations. We see how it's titled. We ask you, is that your intent? And if not, we give you strategies that you can to achieve your intent.
Yeah. So the takeaway is go to the county recorder's website, register your property to get notifications if anybody's trying to tamper with it. If they do, let us know. Let your title company know. Let us know, and we will steer you in the right direction. That's all the time we have for today.
Excellent.
Oh, when did community property with the right of survivorship come into effect?
95.
Oh, okay. So 1995, community property with the right of survivorship became a thing that you could do, and it is very powerful. So if you don't hold title to your property that way, come talk to us. We'll help you out.